All right, picture the pitch. You're a real estate investor being courted for a New Jersey commercial deal, and the man walking you through the numbers isn't just some developer. He's got a sitting New York judge personally vouching for the opportunity, treating it like a sure thing worth his own reputation. That's not a hypothetical. That's the actual scheme two men are now facing federal charges over. And the twist that makes it stick in your head isn't the money. It's that one of them used to decide who else went to prison. Let me lay out exactly what prosecutors say happened, because the details here are the kind that don't need embellishment. The two men are Edward Harold King, a former New York City judge, and Yechiel Spray, who also went by several other names, including Eli Shapiro and Shimon Spray, a real estate developer with real political connections in the city. King wasn't some outsider dabbling in real estate on the side. He'd sat on the bench in an actual courtroom deciding actual cases until he resigned at the very end of last year. And that resignation wasn't a quiet retirement. It came right as the state's Commission on Judicial Conduct was actively investigating him, the same commission that oversees judicial misconduct over complaints that, according to reporting, mirror almost exactly what he's now criminally charged with. Here's the alleged scheme in plain terms. Prosecutors say King and Spray convinced a pair of investors to hand over $6.5 million for what was pitched as a legitimate bid on a New Jersey commercial property. The deal, according to the federal case, wasn't real, or at least not what it was represented to be. And when the investors wanted their money back, they didn't get most of it. Only a fraction ever came back. The rest, prosecutors allege, King used to pay his own personal bills. Sit with that for a second, because it's the part that makes this different from a garden variety real estate scam. This wasn't two random con artists running a Ponzi-style pitch on strangers who had no way of checking their credentials. One of the men pitching this deal was, at the time, an actual sitting judge, someone whose entire professional identity was built on public trust in his judgment and integrity. According to the U.S. attorney overseeing the case, Joseph Nocella Jr., the core of the alleged crime was exactly that, using King's position on the bench to lend false legitimacy to what prosecutors describe as a fake investment opportunity. That's not incidental to the story. Prosecutors are treating it as central to how the fraud worked in the first place. Investors weren't just trusting a business pitch, they were trusting a judge. Now here's how it actually unraveled. This wasn't King and Spray's only alleged scheme, according to the case. An assistant U.S. attorney told the court at the men's initial appearance that the New Jersey property deal was, in his words, one of several schemes federal investigators have been looking into. And when it came to Spray's finances specifically, the prosecutor said flatly that it's safe to describe the amount of money that's moved through his bank accounts over the past few years as many, many millions of dollars. That's not a two-person, one-deal story. That's federal investigators describing a pattern. The arrest itself has its own moment worth knowing, because it says something about how seriously these two apparently thought they could talk their way through anything. When FBI agents took Spray into custody, he reportedly told them he had no electronic devices on him other than his cell phone. Agents searched him anyway, executing a warrant, and found a second phone during the pat-down. Lying to federal agents during an active arrest about something agents can just physically check is its own kind of red flag. It's the sort of small, almost reflexive dishonesty that tends to tell prosecutors everything they need to know about how someone's going to behave once real scrutiny starts. Both men were arrested by IRS criminal investigation agents and appeared before a federal magistrate judge in Brooklyn. King was released on a $250,000 bond. Spray's bond was set at $500,000. If convicted, both men are facing up to 20 years in federal prison. Not civil penalties, not a fine and a stern warning. Actual federal prison time on wire fraud conspiracy charges. Let's be fair here, because right now these are charges, not a conviction, and that distinction matters. Neither man has been found guilty of anything in a courtroom yet. Wire fraud conspiracy cases can be complex, and defendants facing federal charges are entitled to mount a real defense, questioning intent, questioning whether specific representations were actually false versus simply optimistic or mistaken, and questioning how the money was actually used versus how prosecutors are characterizing it. It's genuinely possible parts of this story look different by the time a trial, if there is one, actually plays out. The specific allegation that funds went to King's personal bills, for instance, is exactly the kind of claim a defense attorney would want independently verified line by line, not just accepted because prosecutors said it in a press statement. It's also worth remembering that an arrest and a set of charges, even serious ones, reflect one side's version of events, the government's. That's true in every federal case, not just this one, and it's part of why the American legal system requires prosecutors to actually prove their case, not just allege it persuasively. That said, the surrounding context here isn't neutral. This isn't just a fresh accusation out of nowhere. King's resignation from the bench at the very end of last year came directly alongside a state judicial conduct investigation into complaints that, according to reporting, line up closely with what he's now criminally charged with, including allegations that he was involved in a scheme to defraud real estate investors, and that he continued acting as a lawyer after becoming a judge, including accepting funds into his own attorney escrow account, which is generally something sitting judges aren't supposed to be doing at all. When a criminal case echoes a judicial ethics investigation that closely, it's a lot harder to write the criminal allegations off as an isolated, out-of-character incident. So what actually happens next? Both men are out on bond as the case proceeds through the federal system in the Eastern District of New York. Prosecutors have signaled this may not be the only alleged scheme connected to Spree's finances specifically, which suggests there could be more charges or more victims surfacing as the investigation continues. And King's situation carries an extra layer most defendants don't have to deal with. He's not just facing potential prison time. He's facing it as a former judge, which means every filing in this case is also, in effect, a referendum on how someone spent years inside the system now finds himself on the other side of it. Here's the piece of this worth remembering longer than the headline. The entire alleged scheme worked, according to prosecutors, because of trust that had nothing to do with the actual real estate deal on paper. It worked because a judge's title did the convincing that the numbers apparently couldn't do on their own. That's the actual lesson underneath a story like this. And it's not really about real estate at all. It's about what happens when the exact kind of authority we build our whole legal system around gets pointed at defrauding the people who trusted it most. I'll be watching how this case develops as more of Spree's finances come into view, and if additional schemes or victims surface, that's the next chapter worth covering. 90 years, gone in one ruling. Supreme Court hands, Trump sweeping new power. Somewhere in a Supreme Court opinion released this week is a sentence that quietly rewrote how the entire federal government works, and most people scrolling past the headline had no idea what they were looking at. It doesn't mention Trump by name in its most important line. It mentions a nearly 100-year-old case almost nobody outside a law school has heard of. But the result is this: roughly 24 federal agencies that were built, by design, to operate independently of whoever sits in the Oval Office just lost that independence permanently. Here's exactly what happened and why it matters far beyond the one commissioner at the center of it. Start with the person this case is actually named after. Rebecca Slaughter was a Democratic commissioner on the Federal Trade Commission, first appointed by Trump himself during his first term, then reappointed by President Biden. In March of last year, early in Trump's second term, she got a notice that her continued service was, in the administration's words, inconsistent with its priorities. No accusation of wrongdoing, no claim of incompetence, just not aligned with where we're headed. She was fired, along with a fellow Democratic commissioner, Alvaro Bedoya, who later resigned and dropped out of the case, leaving Slaughter to fight it alone. Here's why that firing wasn't supposed to be legal in the first place. Congress created the FTC back in 1914 and specifically wrote into the law that commissioners could only be removed for cause, inefficiency, neglect of duty, or actual malfeasance. Not political disagreement, not vibes. That protection existed for a reason, and the reason has a name. Humphrey's Executor, a 1935 Supreme Court case that's shaped nearly a century of how the federal government is structured. Quick history, because it actually matters here. Humphrey's Executor came out of a fight between President Franklin Roosevelt and an FTC commissioner named William Humphrey, who Roosevelt wanted gone over policy disagreements tied to New Deal economic regulation. The Supreme Court back then ruled unanimously that Roosevelt couldn't do that. The FTC's work was different enough from purely executive functions, the court reasoned, that Congress could legally insulate it from presidential firing. That single ruling became the foundation for the entire modern landscape of independent federal agencies, The idea that bodies overseeing things like consumer protection, labor relations, and financial regulation should operate with some genuine distance from whoever happens to be president at any given moment. Slaughter sued after her firing, and lower courts sided with her. A federal district court ordered her reinstated. A divided appeals court agreed she could keep her seat while the case continued. This past Monday, it reached the Supreme Court, and the answer came back completely different. 6-3 along the court's ideological lines, the justices ruled Trump did have the authority to fire her, and in doing so, didn't just settle her individual case. They explicitly overruled Humphrey's executor. 90 years of precedent, gone in a single decision. Chief Justice John Roberts, who wrote the majority opinion, put it about as bluntly as a Supreme Court justice ever does. Whatever's left of Humphrey's executor, he wrote, is hereby overruled. The court's reasoning centered on one core idea, that anyone exercising the president's executive power on his behalf has to answer to him and can't be shielded from removal by Congress. Roberts specifically noted the modern FTC enforces roughly 80 different statutes, touching nearly every part of the economy, conducts its own investigations, runs its own in-house legal proceedings, and even files lawsuits on the government's behalf. That's not a quasi-anything in the majority's view. That's executive power, full stop, and executive power answers to the president. Justice Neil Gorsuch, writing separately to support the majority, added a line that's since been quoted everywhere. Independent agencies, he wrote, aren't actually all that independent after all. Now here's where you have to slow down and actually feel the scale of this, because overturning a 1935 case about the FTC undersells it badly. This ruling doesn't just apply to the Federal Trade Commission. The reasoning the court used sweeps across roughly 24 multi-member federal agencies that were built on the same basic legal foundation, bodies that touch nearly every part of daily American life. Sotomayor's dissent specifically named some of what's now exposed: the Federal Energy Regulatory Commission, the Consumer Product Safety Commission, the Nuclear Regulatory Commission, and the Merit Systems Protection Board, among others. Any of them built on Humphrey's executor-style independence just had the legal ground shift underneath them. Justice Sotomayor's dissent is worth hearing at real length because it's one of the sharper rebukes to come out of the court in years. Sharp enough that she took the unusual step of reading a summary of it aloud from the bench, something justices reserve for decisions they find genuinely alarming. Her argument: Congress built multi-member agencies like the FTC specifically to handle complex problems with some independence from total presidential control. And this ruling doesn't just chip away at that. It hands the president power that, in her words, is unknown, even to the English crown the American founders revolted against in the first place. She warned the decision reshapes the entire structure of government, converting what were meant to be semi-independent commissions into purely executive tools that answer to one person's political priorities. Trump's own reaction leaned directly into that framing, just from the opposite angle, celebrating it rather than warning about it. He posted that 90 years of precedent had been completely and unequivocally overruled, calling it a massive increase in presidential power at exactly the moment he believes it's most needed. Senate Judiciary Committee's ranking Democrat, Dick Durbin, put the practical consequence in blunter terms. This president, he said, can now fire whomever he perceives as an enemy at these agencies without so much as citing a reason. Slaughter herself, after the ruling, made a point that's easy to miss under all the constitutional theory. This isn't really an abstract structural question, she argued. It's about whether FTC enforcement decisions get made on the actual facts and merits of a case, or start bending toward whatever's politically convenient for whoever's in office. She said FTC policy will now unquestionably become more political, and added that the politics aren't even the only problem business owners should be thinking about. Let's give real weight to the other side, because the legal reasoning behind this ruling isn't fringe. It reflects a genuine, decades-long argument in constitutional law called the unitary executive theory, the idea that Article 2 of the Constitution vests all executive power in a single person, the president, and that Congress carving out semi-independent pockets of executive authority was always constitutionally shaky, however well-intentioned. Supporters of this ruling point out that Humphrey's executor itself rested on fairly thin reasoning. The original 1935 opinion described FTC commissioners as quasi-legislative and quasi-judicial without much explanation of what that actually meant in practice. and legal scholars across the spectrum have pointed out for decades that the label never held up well under scrutiny. There's also a real democratic accountability argument underneath this. If voters dislike how an agency enforces the law, the theory goes, they should be able to hold the president accountable at the ballot box and get a different approach. Not be stuck with commissioners insulated from any electoral consequence at all. That's not a manufactured talking point invented for this case. It's been a serious current in constitutional scholarship for a long time, and this ruling is its biggest practical validation yet. It's also worth noting the ruling wasn't limitless. Chief Justice Roberts specifically carved out an exception, writing that this decision does not touch the constitutionality of the Federal Reserve's removal protections, a notable distinction, especially given the court ruled the very same day, in a separate case, that Trump could not immediately remove Fed Governor Lisa Cook. The court also explicitly said it wasn't addressing tenure protections for judges on specialized courts like the U.S. Tax Court, leaving those questions, in Roberts' words, for another day. So this is sweeping, but it's not literally everything. The Fed in particular has now been treated by the court as a genuine, distinct exception to this broader trend. So what actually happens now, practically? This ruling doesn't just settle Slaughter's case. Legal experts are already flagging that it will likely control the outcome of similar pending fights, including challenges from a former National Labor Relations Board member and a former Merit Systems Protection Board member who were removed under similar circumstances earlier in Trump's term. Their cases were being argued on very similar legal grounds, and this ruling makes it far less likely either of them succeeds in getting their jobs back. More broadly, expect this to become the new baseline anytime a future president of either party decides to clean house across independent agencies. The legal shield that used to exist is functionally gone for the vast majority of them. Here's the honest way to leave this one. This is a genuinely massive shift in how the federal government is structured, not a narrow employment dispute about one commissioner. Whether you think that's a correction of nearly a century of constitutional overreach or a dangerous concentration of power in one office depends entirely on which side of the unitary executive debate you already found persuasive. And this ruling just made that debate a lot less theoretical. The agencies affected regulate huge parts of daily life: consumer products, energy, workplace safety, financial practices. How quickly and how far this actually reaches into all of them is the thing worth watching next. Because Monday's ruling was the foundation, the follow-on cases are where we'll actually see how far it goes.